here. When he's not in court, we'll live it through. Good morning. Thank you for having me. You know, it's good to see a lot of friends here today. About a year ago, BamaCarry took me in. I gotten to go around the state and talk about some of the things I'm going to talk about today with the Stand Your Ground law, but I've been fortunate to go to Jefferson County and Marshall County and Marengo and Tuscaloosa, Blount, Coleman, Marshall, Madison, and so it's good to be here with you at your Freedom Conference. I want to introduce my family who's joined me today. To my right over here is my wife, Emily. My youngest son, Charles, is raising his hand, and my oldest son, Henry, in the bomber jacket next to them. But yeah, Charles, I see you over there. Now, usually when I'm making this presentation, I will allow time for questions at the end. And so if anyone has questions, feel free to speak up. I have some hard copies of my presentation. If anyone wants this, it's got the Stand Your Ground law in it. I'll be glad to give that to you after we finish. I've also submitted it to BamaCarry to either put it on the website or email it out to you. So they have that as well. So I have to tell you, and some of you have heard this story. Last summer, I was on my way to the BamaCarry meeting in Tuscaloosa County. And this song came on the radio. And it caught my eye because on my radio it lists the title of the song, and it said, "No Lawyers in Heaven." Which kind of offended me. And,
go to your safe space.
That's right. And so I started listening to it, and I looked up the lyrics and share a couple of those with you. I got mugged my first day in town. I jumped on that mugger's back when I chased him down. His counsel claimed I used excessive force. His client suffered whiplash and undue mental stress. Now he's occasionally depressed. I hope that after the next 20 or so minutes that this will be helpful to you and you won't be singing the blues. And so, stand your ground. What is it and what is it not? That's what we're going to talk about today. Now, and let me just say one more note about my family before I get into the law, about what stand your ground is not. My oldest son, Henry, has been to a couple of these with me. And not long ago, in my house, I heard my youngest, Charles, just screaming. And I walk in the room, and Henry is standing over him. And I said, "Henry, what did you do to him?" And Henry said, "I was just exercising my rights under the Stand Your Ground law." Let's talk about why that doesn't qualify. So the Stand Your Ground law provides no duty to retreat and justifies the use of force in defending yourself or someone else when you reasonably believe you are facing the imminent use of physical force. Your belief must be reasonable as to the threat which is facing you. And the law says a reasonable belief is one formed in reliance upon reasonable appearances. It's not a belief that's formed recklessly or negligently. And the test is not whether or not you are correct in your belief, but whether your belief was reasonable. And people ask me to give an example of that. Well, I'll give you an example of that. Let's say you are walking through a dark alley and you see a gun pointed at you, and you have to protect yourself. Well, it turns out the gun you saw was a cap gun and not a real gun. Would it have been a reasonable belief that it was a real gun? Maybe so. That's just an example of a reasonable belief of the force you are facing. Now, very important, the stand your ground law is different from common law self-defense. 33 states have some form of stand your ground, which is a form of immunity. Immunity. So here's the difference. Under self-defense, you go to court, and a judge or a jury decides whether or not you were defending yourself, whether or not you had the right to defend yourself. Under the stand your ground law, you are entitled to a pre-trial evidentiary hearing, where a judge decides whether or not the stand your ground law applies to you, whether or not you were acting reasonably. No jury, just a judge. And if the defendant prevails there, it's over. And the immunity, we're talking criminal immunity and civil immunity. I know the self-defense fund folks are here. The threat of lawsuits when you use a gun is just a reality, okay? But if you are justified under the stand your ground law, you have immunity both criminally and civilly. Now, people say, who's the burden of proof on, right? Let's say you get charged criminally. We all have heard they got to prove you guilty beyond a reasonable doubt, right? Well, in the stand your ground context, if you are asserting that defense, the burden is on you as the defendant. And the burden is a preponderance of evidence, which is a low standard. But if you are asserting stand your ground immunity, it is your burden to show that your use of force was justified. Okay? Any questions about any of that so far, about the burden of proof? Now, I'm going to give you some examples, but before I do, let's talk about the difference between the stand your ground law and the castle doctrine. Okay? We all know the castle doctrine. Goes back hundreds of years, that someone's home is their castle. And that's what the law used to be in Alabama, which said if you were in your home and someone is coming in on you, then you've got the right to defend yourself. The stand your ground law takes that a step further. Under the stand your ground law, you don't have to be in your home. It's anywhere you have a right to be, okay? In public, at a hotel where you're staying, at Walmart, in a restaurant, wherever you have a right to be, you have the right to assert the stand your ground law. So it moves the old castle doctrine from your home to outside your home, okay? And an example that I give, it's in my paper, is if you're in a castle state and you catch a home intruder, you can run away or stand and fight, your choice. If you live in a stand your ground state, you have that same choice if you walk up on a mugging on the street or you're about to be mugged yourself, okay? It goes beyond the home. Now, there are several examples in the law. The most common one that we see is when someone is face to face with a bad actor who they reasonably believe is going to use deadly physical force, okay? A holdup, a mugging, a robbery, something of that nature. The stand your ground law also applies to home invasions and to protection of others, okay? If there is a robbery going on, say at a business, and you're driving by, you see that going on, I'm not saying you should stop, you should call the police. But the stand your ground law does extend to defenses of other people. Now, what it does not apply to is defense of property, okay? If somebody is tearing down your mailbox, or tearing down your fence post, and you go out there and shoot them, you're going to jail. Stand your ground does not apply to that. And I've gotten a lot of questions about this, and a lot of people disagree with that, but you absolutely cannot do that. There has to be a threat to you or someone else physically. Now, I'll give you an example. There is a case in another county where a man walked outside his house last December, and he saw his own truck headlights speeding away. Okay? He thought someone was stealing his vehicle. It certainly looked that way. So he gets he has a deer rifle on him, and he fires to the back of the truck and hits the occupant. Okay? Turns out it was his son, and he's now charged with manslaughter. And he's charged with manslaughter because you cannot use deadly physical force in order to protect personal property. Okay? Now, there are some exceptions. Let's say that you witness what you think is a home invasion of someone else, and you interfere and you use force to stop that threat. If it turns out you were wrong, and the person you thought was a bad guy actually had a right to be there, say he locked his keys outside and is breaking in the window, stand your ground immunity does not apply to that situation if you become involved in it. Stand your ground immunity applies to defense of a child. But if it turns out you're wrong, and the person who you see carrying a child, putting a child in a car, that they actually had a right to do so, you don't have stand your ground immunity for that. Probably the most important point is you cannot be breaking the law. You have to be in a lawful place, lawful time, with a lawful purpose in order to have stand your ground immunity. You can't be the initial aggressor. You've got to have a right to be there, and you can't be breaking the law. I'll give you an example. There was a case in North Alabama last year where a drug deal went bad. And there was a shooting, fatality, and the shooter was put on trial. Well, the shooter says he should be entitled to stand your ground immunity because the person he shot started it. But this defendant was a convicted felon, had no right to own a gun, certainly had no right to be involved in an illegal drug deal. He's breaking the law. What do you think happened to his stand your ground claim? It was denied. It was denied. Now, even though his stand your ground claim was denied, he was still allowed to plead self-defense. Okay, you can always plead self-defense, and it's up to a judge whether or not to give that instruction to a jury. But because stand your ground is a form of immunity, then there are very strict guidelines by which it applies to you. So just remember, lawful place, lawful purpose, lawful time. You can't start it, you can't be the initial aggressor. You can't be fighting the police. Okay. There is a case pending right now in the state of Florida in the appellate courts where a police officer is on trial for a shooting. And the police officer who is charged with the crime has asserted the stand your ground defense. Florida has the same, pretty close to the same stand your ground law that Alabama does. And the appellate courts in Florida are deciding whether or not a police officer has the right to assert stand your ground liability. Now, I don't know about you. My own opinion is that a police officer doesn't have any less rights than someone else. Okay? And I represent police officers through the Police Benevolent Association, and it just makes sense that they have those same rights, especially when they're protecting the rest of us. One other little quirk in the stand your ground law that I always mention, I'm going to read this directly from the statute, that it does not apply if, quote, the physical force was the product of combat by agreement. So if we've got anybody who likes to duel out here, you may get self-defense, but you're not getting stand your ground. Okay? You cannot have any dueling. One thing I mentioned a few minutes ago was that you are entitled to this pre-trial hearing, and that is true in both civil and criminal cases. When the law was first passed, it wasn't clear whether or not you got a pretrial hearing. And in 2016, Alabama's legislature amended the law and said, yes, you get this pretrial evidentiary hearing. And it only makes sense that you do. Now, the law does not say how far in advance of trial you get your pretrial hearing. I had one where we did it the morning of. It's kind of tough. But generally, it will be with enough time, weeks or even months before a trial. Okay? So here's the key, BamaCarry. You have the right to stand your ground so long as you aren't breaking the law, you're somewhere you have a right to be, and you were not the initial aggressor. Okay? Questions? Anybody have questions? All right, Charles, I will answer your question on the way back to Colton. All right. Yes, sir.
One thing that's been happening up, like in Wisconsin, a whole lot of police officers have been invading other people's homes than what is on the warrant. If a family has to go through that and they don't know who's coming through the front door, what happens if they start shooting at the police officers or whoever law enforcement is?
Yes, sir. Well, let's think about it. Just under the stand your ground context, homeowner is somewhere they have a right to be. They, assuming they're not breaking the law, not the initial aggressor. I think it would come down to what happened on a case-by-case basis. Did the officers who were at the wrong place, did they identify themselves? Were they, what were they wearing? Did they announce that they were police? Certainly, if they announced they were police, I would say that the homeowner should stand down. But if somebody comes in and does not identify themselves, and it looks like a break-in, then I think it's going to come down to what their reasonable belief was in that situation. Thank you. Any other questions? Yes, sir.
Could you clarify for me who's the initial aggressor? So if they come through the home, is that defined as they're initiating the aggression?
Yes. Because if there is a forcible entry into your home, then it is presumed that person means you harm. Okay. Yes, sir.
I am not an attorney, and I have not stayed at a Holiday Inn Express. But my question is this. I had people comment in my presence that if you carry a firearm, you have lost your right to get angry about anything and to get into an argument. And I know that many arguments, start out as verbal and then somebody crosses the threshold into violence. Take road rage, for instance. Obviously on a highway, everybody's where they're supposed to be, where they have the right to be. Something happens and they get into some sort of a confrontation. At what point do you have more rights than the other person, let's say, to defend yourself against them when the argument appeared to have been started mutually?
It's probably going to be an issue of fact, but I think the line is going to be where, at what point do you have the reasonable belief that you're about to be harmed physically? At what point do you reasonably believe that this is more than just an argument? Okay, and in a lot of cases, these things have to be decided in court by a judge, by a jury, which side has the more credible theory, which side has the most convincing case, and that may come down to the quality of the evidence you have. There was a successful stand your ground defense in Tuscaloosa County for an incident that happened at a Shell station in Tuscaloosa, and it just so happened the whole thing was caught on video, and so it was easy for the court to see that the person charged was not the initial aggressor and was justified in using force. But that's the exception. In most cases, it's not caught on video, and so it's going to come down to when did it escalate. Bruce?
Just one quick thing before you speak. If y'all guys in the back or anywhere, if you're speaking, please speak softly, because I can hear from the outside out there, people talking. It's a little bit disruptive to us in here. Thank you for your patience on that.
In the stand your ground law, where does that come into effect? Like, say you're in a parking lot and you're being approached and you're telling someone to stop and they won't stop. You may not see a weapon, but there's always that potential. I mean, you don't see one on me now, but I'm armed. So you've got someone approaching you and you're telling them to stop. You don't know what they're up to. At what point does that kick in that you have a right to act?
Well, in a parking lot, I mean, first, that's somewhere you have a right to be, okay? And when someone is approaching you and you're telling them to stop and they keep coming, then it may depend, it's going to depend on several things. What are they saying? Are they threatening you? Is it someone who you know? Is it someone you have a history with? Is it, what is the relationship between the parties? If you've got, say, someone who is disabled or sick or in a wheelchair, and they're telling, a 6 foot tall guy to stop coming towards them, the court might look at that different than if, say, you or I was in that position. So it's going to depend on the context and of the circumstances, and what it comes down to is what is reasonable. And what is reasonable under the circumstances is just going to depend. I can think of scenarios, and you can too, where it might be reasonable to use force, and it might be unreasonable to use force, and it's just going to depend. Before the next question, I can see y'all can't, but our Lieutenant Governor Will Ainsworth is here. I just want to welcome him, and I know he's been a friend of BamaCarry. Appreciate the work he's doing. Yes, Bruce.
And I would highly recommend that everybody has self-defense fund coverage.
Thank you. Josh Lee, Madison County. I'm also a retired police officer, so I kind of know part of the answer to this. Use of force continuum, as it is in a court, as it is out on the street. How does that transfer over to civilian use in a courtroom? And also, is there education on that available for people who have never even heard of use of force continuum?
The use of force, say that again for me, please.
Which part?
You said the use of force continuum?
Right, as it pertains to law enforcement, as opposed to how it pertains to a civilian, non-law enforcement individual?
Sure. So, that's an issue. The Alabama courts have not tackled that under the stand your ground law that I've seen. I know Florida is looking at that now. I know in some cases where, say, a law enforcement officer is being prosecuted, I heard it argued that they should be held to somewhat of a higher standard than someone else because of their background, training, and experience. And that's something it's kind of a slippery slope when you get into that. And normally a law enforcement officer who's on trial will argue that be disallowed, that they not be held to a higher standard than someone else, that they be held to just the reasonable person standard that we all are. Yes, sir.
Yes, sir. I'm with Blunt County, BamaCarry. With most everyone on social media now and posting memes, make my day, a lot of pro-Second Amendment memes, can that be held against you if you have to use your weapon in self-defense?
I'm really glad he asked that question. Did everybody hear it? Can your Facebook post be used against you? You betcha. People's social media history comes in on every kind of case. Criminal case, civil case, divorce case, you name it, social media is coming in. And if you have you mentioned a pro-Second Amendment post, there have been cases where a good plaintiff's lawyer or a good prosecutor prosecuting someone will get those and say that that is evidence of intent, of a predisposition to be trigger happy. And so, absolutely, but anything that is on social media is going to be talked about in court. And yes, someone can argue that there's an inference to be gleaned from your social media post. Yes, sir.
Can workplace policy be brought into the courtroom? For instance, I'm a firefighter in Huntsville, and if one day we get a call and I happen to forget to disarm when I go to work and have to use that gun as self-defense, can the workplace policy play into that case?
I think that could go either way. It's sometimes things like workplace policies and things of that nature are held to be prejudicial or unfairly prejudicial because a jury might attach too much weight to that. And certainly if you were in that situation, you would probably want that not to come in because it's just one more thing you're on trial for. Okay, a lot of times in cases, if you bring in that, then I think it would be unfairly prejudicial because it could be, well, if you're not guilty of this, you're guilty of something, right? So that would be subject to a pretrial motion, most likely to exclude it. Yes, sir.
Yes, sir. I'm a resident of Tuscaloosa County, and we have a driveway that's between two roads, and there's a Dollar General on the back of it. I keep having people coming through. I put up fences, I put up signs, say anything you want to stay on, stay out. No through road, no pass. I've had people come with 18 dualies, 20-foot trailers go around at 40 miles an hour around my house, keep flying out there. I've stopped a few people. I don't take it, I might have a gun in my hand, but I don't aim at them, I don't throw my fist at them, raise cane. I've tried to keep them stopped, and I've asked the county, he said, what do you do? He said, well, you gotta let them go. I said, well, it's not a matter of letting them go, I just like them not to come through. And then a state trooper told me, well, just go ahead and shoot them. But is there anything that can be done like that? If I put a gate up, I've already paid $2,000 for everything. I've got to put another gate up, but I don't have a fence across. And if that gate's shut and they come around the fence, or no fence, they won't come around with a question, they'll get stuck. But if I put the gate up and I'll open it or stuff like that, they come around, do I have any rights on that?
Well, I think you've probably got rights to enforce civilly or trespass and them coming on your property. I think you can do that. I think you should talk to a lawyer in Tuscaloosa about what you can do to keep them off your property. I don't agree with the state trooper.
And he most definitely needs that coverage.
Yeah, that's right.
What if the aggression is over? Somebody's already beat you to the ground, you're walking off, does your standing ground cover you now?
You know, that is a great question. What if it's over? I mean, you're beat, you're on the ground, and they're walking off. I would say stand your ground immunity would probably not apply in that point. It's, you know, of course, it's going to depend on the circumstances. If you're worried about him coming back, then it might. All right. Well, have your hand raised. Question.
My name is Brian Bentley. I'm with the Cleveland County chapter, used to be in Tuscaloosa. A lot of things have come into play with commercial vehicles. I posted a thing the other day, and the question was, most of these drivers live in their truck a majority of the time. And there's certain federal guidelines and stuff like that that are being proposed now. If a driver of a commercial truck is defending himself, what would that involve from a stand your ground in the state of Alabama?
Well, certainly I think if he's a licensed commercial vehicle driver in his truck, that's somewhere he's got a right to be. Assuming he's not breaking any laws, and he's not the initial aggressor, then I think it would probably apply, because under the stand your ground law, it doesn't matter whether you're in your home or not. You know, certainly he can argue that his truck is his home, but it doesn't matter because, as long as he's somewhere he has a right to be, right, in his truck, at a truck stop, wherever. Yes, sir. We are winding down on time. I may have time for one or two more questions.
Anybody got a question, raise your hand. I see you in front.
Assuming someone stops someone in the commission of another crime and then it escalates. For example, somebody is, say, breaking into the shed, you stop them, hold them at gunpoint for the police to arrive, and they decide that they're going to take the gun away from you. Stand your ground, even though you initiated it by saying, you know, quit stealing my things, and you're going to stay here till the police get here. The guy says, no, I'm not, I'm fixing to take the gun. Then how does that play out?
You initiated contact, but you didn't initiate the aggression. The person breaking in initiated the aggression. And so I would think under the facts as you've described them, that stand your ground probably would apply. I just noticed Mr. Ziegler's here, another statewide elected official. Appreciate him being here today. Two more?
Thank you. I get off work at 8:30, I have privacy fence around my house. If I get out of my truck at night and someone, like, especially during the summer months, walking back and forth, comes into my property, and I have physical problems and an altercation physically, I would probably not do very well to defend myself. If I tell them to stop, and they do not, even if they're unarmed, they continue toward me, do I have the right at that time to shoot them? Because I've already got one strike against me, I'm a gun owner and I'm a postal worker.
You know, it's would say if the more that escalates, the more of a stand your ground situation it could turn into. I don't think that just the mere presence, them being there would get you there, but certainly if you know, the more it escalates, the closer they are to you under your circumstances, maybe. Okay, may depend on what the relationship is, if they knew about your physical problems. Yes, sir. Last question.
At which point does a vehicle become a lethal weapon and you gain your standard room?
At what point does a vehicle become a lethal weapon? I have defended a case where one party was on a tractor and another party had a gun. And the party on the tractor attempted to run over someone, and the man with the gun stopped it. Okay? There have been other cases I've seen, there's other cases I've defended where someone attempted to use a motor vehicle as a weapon. So yes, the bad guy does not have to have a knife or gun. It can, certainly a vehicle can be a lethal weapon, and stand your ground would apply there. Y'all got a great program today. I wish I could stay for it, but I have got to get back to Coleman after this presentation. Henry has a basketball game at 12:30. But if anyone wants any more information, you can email me, champ@champcrocker.com. I'm on Facebook, Twitter, all that. And BamaCarry's got a copy of my presentation for today, but if you want to email me, I can send it to you directly, or you can get it from them. Thank you all for your questions, for your attentiveness, and for being here today. It's certainly been an honor.